Welcome to Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload daily at 8 a.m. Eastern Standard Time. Please ring the notification bell, like, and subscribe so you can be updated every day as we upload new content. Question number 1. On trial for murdering her husband, defendant testified she acted in self-defense. Defendant calls expert, a psychologist, to testify that under hypnosis, defendant had described the killing and that in expert's opinion, defendant had been in fear for her life at the time of the killing. Is expert's testimony admissible? A. Yes, because expert was able to ascertain that defendant was speaking truthfully. B. Yes, because it reports a prior consistent statement by a witness subject to examination concerning it. C. No, because reliance on information tainted by his hypnosis is unconstitutional. Or D. No, because it expresses an opinion concerning defendant's mental state at the time of the killing. Take 10 seconds, choose the best answer. If you chose option D, no, because it expresses an opinion concerning defendant's mental state at the time of the killing, you'd be correct. Under the federal rules of evidence in a criminal case, an expert witness must not state an opinion about whether the defendant did or did not have a mental state or condition that constitutes an element of the crime charge or of a defense. Those elements are for the trier of fact alone. As such, the expert's testimony is inadmissible because it expresses an opinion concerning the defendant's mental state at the time of the killing. Question number 2. Owner owned Green Acre, a tract of land, in fee simple. Owner executed an instrument in the proper form of a deed, purporting to convey Green Acre to purchaser in fee simple. The instrument recited that the conveyance was in consideration of $5 cash in hand, paid and for other good and valuable consideration. Owner handed the instrument to purchaser, and purchaser promptly and properly recorded it. 2 months later, owner brought an appropriate action against purchaser to cancel the instrument and to quiet title. In support, owner proved that no money in fact had been paid by purchaser, notwithstanding the recitation, and that no other consideration of any kind had been supplied by purchaser. In such an action, owner should A. Lose, because any remedy owner might have had was lost when the instrument was recorded. B. Lose, because the validity of the conveyance of land does not depend upon consideration being paid, whether recited or not. C. Prevail, because the recitation of consideration paid may be contradicted by parole evidence. Or D. Prevail, because recordation does not make a void instrument effective. Take 10 seconds, choose the best option. If you chose option B, you'd be correct. Lose, because the validity of conveyance of land does not depend upon consideration being paid, whether recited or not. The requirements for the lawful execution of a deed are 1. That it be in writing. 2. That it describe the land in question. 3. That it identify the parties in question or the parties to the conveyance. 4. Specify some price or state some other consideration. And number 5. Signed by the grantor. While a land sale contract must specify the price or state some other consideration, consideration is not in fact actually necessary for the lawful execution of the deed. In this case, owner executed an instrument in the proper form of a deed, purporting to convey Green Acre to purchaser in fee simple for $5 cash in hand and for other good and valuable consideration. 2 months later, owner brought an appropriate action against purchaser to quiet title and prove that purchaser in fact paid no money. However, since consideration is not required for a valid conveyance of real property by deed, owner should in fact lose. Question number 3. Adam's car sustained moderate damage in a collision with a car driven by Basher. The accident was caused solely by Basher's negligence. Adam's car was still drivable after the accident. Examining the car the next morning, Adam could see that a rear fender had to be replaced. He also noticed that gasoline had dripped onto the garage floor. The collision had caused a small leak in the gasoline tank. Adam then took the car to a mechanic, who owns and operates a body shop, and arranged with the mechanic to repair the damage. During their discussion, Adam neglected to mention the gasoline leakage. Thereafter, while the mechanic was loosening some of the damaged material with a hammer, he caused a spark, igniting vapor and gasoline that had leaked from the fuel tank. Mechanic was severely burned. Mechanic has brought an action to recover damages against Adam and Basher. The jurisdiction has adopted a pure comparative negligence rule in place of the traditional common law rule of contributory negligence. In this action, will Mechanic obtain a judgment against Basher? Your four options are this. A. No, unless there's evidence that Basher was aware of the gasoline leak. B. No, if Mechanic would not have been harmed had Adam warned him about the gasoline leak. C. Yes, unless Mechanic was negligent in not discovering the gasoline leak himself. D. Yes, if Mechanic's injury was a proximate cause of Basher's negligent driving. Take 10 seconds, choose the best option. If you chose option D, you'd be correct. Yes, if Mechanic's injury was a proximate consequence of Basher's negligent driving. To establish prima facie case of negligence, the plaintiff must prove 1. A duty, 2. Breach of that duty, 3. Causation, and 4. Damages. The doctrine of proximate cause is the philosophical connection which limits liability to consequences that bear some reasonable relationship to the defendant's conduct, so as to not offend notions of common sense, justice, and logic. In this case, Basher's negligence caused a gas leak in Adam's car, and Mechanic was severely burned while trying to repair the damage. Since Mechanic's injury is a bit removed from Basher's negligence, Mechanic will obtain a judgment against Basher if Basher's negligent driving is determined to be the proximate cause of Mechanic's injury. Otherwise, he will not have the ability to collect against Basher. Question number 4. Matt and his friend Fred were watching a football game at Matt's home when they began to argue. Fred became abusive, and Matt asked him to leave. Fred refused, walked into the kitchen, picked up a knife, and said he would cut Matt's heart out. Matt pulled a gun from under the sofa, walked to the front door, opened it, and again asked Fred to leave. Fred again once refused. Instead, he walked slowly towards Matt, brandishing the knife in a threatening manner. Matt, rather than running out the door himself, shot in Fred's direction, intending only to scare him. However, the bullet struck Fred, killing him instantly. Charged with murder, Matt should be A. Convicted because the use of the deadly force was unreasonable under the circumstances. B. Convicted because he had a clear opportunity and duty to retreat. C. Acquitted because he did not intend to kill Fred. D. Acquitted because he was acting in self-defense and had no duty to retreat. Take 10 seconds. If you chose option D, acquitted because he was acting in self-defense and had no duty to retreat, you'd be correct. A victim may use deadly force in self-defense if the victim is not at fault. The victim is confronted with unlawful force, and the victim reasonably believes that they are facing imminent threat of death or great bodily harm. The majority rule is that there is no duty to retreat, and the minority rule is that there is no duty to retreat if the attack takes place in the victim's home. In this case, Fred became abusive, then walked into the kitchen and picked up a knife and said he would cut Matt's heart out. Clearly, Matt was not the initial aggressor. When Matt opened the front door and asked Fred to leave, Fred again refused and walked slowly towards Matt, brandishing the knife in a threatening manner. Matt was being confronted with unlawful force, and Matt reasonably believed he was facing death or great bodily harm. Matt could have retreated out the door, but he was under no legal obligation or duty to do so, under either the majority rule or the minority rule, because Matt was in his own home. Therefore, Matt should be acquitted of murder because he was acting in self-defense and had no legal obligation to retreat. Question number 5. Landholder was land rich by inheritance, but money poor, having suffered severe losses on bad investments, but still owned several thousand acres of unencumbered timberland. He had a large family, and his normal, fixed personal expenses were high. Pressed for cash, he advertised a proposed sale of standing timber on a choice 2,000-acre tract. The only response was an offer by Lager, the owner of a large integrated construction enterprise, after inspection of the advertised tract. For this question only, assume the following facts. Lager offered to buy, sever, and remove the standing timber from the advertised tract at a cash price 70% lower than the regionally prevailing price for comparable timber rights. Landholder, by then in desperate financial straits and knowing little about timber values, signed and delivered to Lager a letter accepting the offer. If, before Lager commences performance, landholder's investment fortunes suddenly improve and he wishes to get out of the timber deal with Lager, which of the following legal concepts affords his best prospect of effective cancellation? A. Bad faith. B. Equitable estoppel. C. Unconscionability. Or D. Duress. Take 10 seconds and choose the best option. C. Unconscionability. If you chose that, you'd be correct. A court has the power to refuse to enforce a provision or an entire contract to avoid unconscionable terms. A contract may be voidable where the clauses are so one-sided as to be unconscionable under the circumstances existing at the time the contract was formed. Contracts induced by duress or coercion are voidable. Here, the landowner Lager contract looks rather one-sided. Landowner knew little about timber values, whereas Lager was the owner of a large integrated construction enterprise. Lager's cash offer was 70% lower than the regionally prevailing price for comparable timber rights, which may be unconscionable under these circumstances. While Lager's offer may have been unconscionable, it was not based on deception or misrepresentation, so N, B, in fact, do not apply. Furthermore, Lager did not induce landholder to enter into the contract by duress or coercion, so D does not apply. Therefore, the best legal concept affording landholders best prospect for success or in canceling this contract would be the theory of unconscionability. C. Question number 6. Plaintiff sued defendant for injuries suffered in a car accident allegedly caused by brakes that had been negligently repaired by defendant. At a settlement conference, plaintiff exhibited the brake shoe that caused the accident and pointed out the alleged defect to an expert, whom defendant had brought to the conference. No settlement was reached. At trial, the brake shoe having disappeared, plaintiff seeks to testify concerning the condition of the shoe. Plaintiff's testimony is A. Admissible because defendant's expert had been able to examine the shoe carefully. B. Admissible because plaintiff had personal knowledge of the shoe's condition. C. Inadmissible because the brake shoe was produced and examined as part of a settlement negotiation. D. Inadmissible unless plaintiff establishes that the disappearance was not his fault. Take 10 seconds, choose the best answer. If you chose option B, you'd be correct. Admissible because plaintiff had personal knowledge of the shoe's condition. Under the federal rules of evidence, in order to satisfy the federal rules of competency, a witness must have observed the fact testified to and must have present recollection. So in essence, the witness must simply have knowledge of what they're testifying to. In this case, the plaintiff seeks to testify concerning the condition of the brake shoe, a fact he is familiar with since he exhibited the brake shoe at the settlement conference and actually pointed out the alleged defect to the defendant's expert. Since the plaintiff clearly has personal knowledge of the condition of the brake shoe, his testimony should in fact be admissible. Option B, as a result, would be your best choice. Question number 7. Venn owned Goldacre, a tract of land, in fee simple. Venn and Pure entered into a written agreement under which Pure agreed to buy Goldacre for $100,000, its fair market value. The agreement contained all of the essential terms of a real estate contract to sell and buy, including a date for closing. The required $50,000 down payment was made. The contract provided that in the event of Pure's breach, Venn could retain the $50,000 deposit as liquidated damages. Before the date set for the closing in the contract, Pure died. On the day that Addie was duly qualified as administratrix of the estate of Pure, which was after the closing date, Addie made a demand for return of the $50,000 deposit. Venn responded by stating that he took such demand to be a declaration that Addie did not intend to complete the contract and that Venn considered the contract at an end. Venn further asserted that Venn was entitled to retain as liquidated damages the $50,000. The reasonable market value of Goldacre had increased to $110,000 at that time. Addie brought an appropriate action against Venn to recover the $50,000. In answer, Venn made no affirmative claim, but asserted that he was entitled to retain the $50,000 as liquidated damages as provided in the contract. In such a lawsuit, judgment should generally be made for A. Addie, because the provision relied upon by Venn is unenforceable. B. Addie, because the death of Pure terminated the contract as a matter of law. C, then, because the court should enforce the express agreement of the contracting parties. Or D, then, because the doctrine of equitable conversion prevents termination of the contract upon the death of a party. Take 10 seconds, choose the best option. If you chose option A, ADDI, because the provision relied upon by then is unenforceable, you'd be correct. To have a valid liquidated damages clause, you need 1. Damages must be difficult to ascertain. 2. The damages must be a reasonable forecast. And 3. The damages cannot operate as a penalty. Liquidated damages clauses are presumptively invalid when the damages figure is a single set number no matter what the breach, because this is not considered a reasonable forecast. In this case, the liquidated damages clause was for a single set number, $50,000, regardless of when Pure's breach occurred, so this is not a reasonable forecast of the damages. Therefore, this provision would be unenforceable and the judgment should be for ADDI. Question number 8. Adam's car sustained moderate damage in a collision with a car driven by Basher. The accident was caused solely by Basher's negligence. Adam's car was still drivable after the accident. Examining the car the next morning, Adam could see that a rear fender had to be replaced. He also noticed that gasoline had dripped onto the garage floor. The collision had caused a small leak in the gasoline tank. Adam then took the car to a mechanic who owns and operates a body shop and arranged with the mechanic to repair the damage. During their discussion, Adam neglected to mention the gasoline leakage. Thereafter, while the mechanic was loosening some of the damaged material with a hammer, he caused a spark, igniting vapor and gasoline that had leaked from the fuel tank. Mechanic was severely burned. Mechanic has brought an action to recover damages against Adam and Basher. The jurisdiction has adopted a pure comparative negligence rule in place of the traditional common law rule of contributory negligence. In this action, will mechanic obtain a judgment against Adam? A, no, because it was mechanic's job to inspect the vehicle and repair whatever needed repair. B, no, unless Adam was aware of the risk that the gasoline leak represented. C, yes, if a reasonable person in Adam's position would have warned the mechanic about the gasoline leak. Or D, yes, because the car was unreasonably dangerous when Adam delivered it to the mechanic. Take 10 seconds, choose the best option. If you chose option C, you'd be correct. Yes, if a reasonable person in Adam's position would have warned mechanic about the gasoline leak. To establish a prima facie case of negligence, the plaintiff must show 1. A duty, 2. A breach of that duty, 3. Causation, and 4. Damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect the plaintiff against an unreasonable risk of injury. A duty of care is owed to all foreseeable plaintiffs, and the extent of this duty is determined by the applicable standard of care. The basic standard of care is that of a reasonable person of ordinary prudence in the defendant's position. Here, a reasonable person of ordinary prudence in Adam's position may have warned the mechanic about the gasoline leak. By failing to warn the mechanic, Adam may have breached his duty of care to protect mechanic against unreasonable risk of injury from the leaking gasoline vapor igniting. Thus, mechanic will be able to obtain a judgment against Adam if a reasonable person, in fact, in Adam's position, would have warned the mechanic about the gasoline leak. Almost at the finish line. Question number 9. Hannah, who was homeless, broke into the basement of a hotel and fell asleep. She was awakened by a security guard who demanded that she leave. As Hannah was leaving, she cursed the security guard. Angered, the security guard began to beat Hannah on her hand with his flashlight. After the second blow, Hannah grabbed the fire extinguisher and sprayed the guard in his face, causing him to lose his sight in one eye. The jurisdiction defines aggravated assault as assault with intent to cause serious bodily injury. The most serious crime for which Hannah could properly be convicted is A. Aggravated assault, B. Burglary, C. Assault, D. Trespass. Take 10 seconds and choose what you believe to be the best answer. If you chose option D, trespass, you'd be correct. At common law, burglary is the trespassory breaking and entering of a dwelling at nighttime with the specific intent to commit a felony or larceny inside. Furthermore, a non-aggressor victim may use non-deadly force in self-defense anytime the victim reasonably believes that force will be used against her. In this case, Hannah broke into the basement of a hotel and fell asleep. Since Hannah did not break into the hotel with the specific intent to commit a felony or larceny inside, Hannah cannot be found guilty of burglary. Furthermore, since Hannah used non-deadly force in self-defense after the guard began to beat her on the hand with his flashlight, Hannah cannot be convicted of aggravated assault or assault. As such, the most serious crime for which Hannah could properly be convicted would be the trespass for entering the building. Okay, let's move on to the last question in this grouping, question number 10. An ordinance of Central City requires every operator of a taxi cab in the city to have a license and permits revocation of that license only for good cause. The Central City Taxi Cab Operators Licensing Ordinance conditions the issuance of such a license on an agreement by the licensee that the licensee not display in or on his or her vehicle any bumper sticker or other placard or sign favoring a particular candidate for any elected municipal office. The ordinance also states that it imposes this condition in order to prevent the possible imputation to the City Council of the views of its taxicab licensees, and that any licensee who violates this condition shall have his or her license revoked. Driver, the holder of a Central City Taxicab Operator's license, decorates his cab with bumper stickers and other signs favoring specified candidates in a forthcoming election for municipal offices. A proceeding is initiated against him to revoke his taxicab operator's license on the sole basis of that admitted conduct. In this proceeding, does driver have a meritorious defense based on the United States Constitution? Let's look at our four options. Option A, no, because he accepted the license with knowledge of that condition and therefore has no standing to contest it. B, no, because a taxicab operator's license is a privilege and not a right, and therefore it is not protected by due process clause of the 14th Amendment. Option C, yes, because such a proceeding threatens driver with a taking of property, i.e. his license, without just compensation. Or D, yes, because the condition imposed on taxicab operator's license restricts political speech based wholly on its content, without any adequate governmental justification. Take 10 seconds, choose the best answer. If you chose option D, you'd be correct, yes, because the condition imposed on taxicab operators' licenses restricts political speech based wholly on its content without any adequate governmental justification. For a content-based restriction of protected speech to be valid, the restriction must pass strict scrutiny. This means the restriction must be necessary to achieve a compelling governmental interest. Here, Central City Taxicab Licensing Ordinance restricts a licensee from displaying any bumper sticker, placard, or sign favoring a particular candidate for any elected municipal office. This is a content-based restriction of protected speech, so it must pass strict scrutiny in order to be constitutionally valid. Driver can argue that the restriction fails to pass strict scrutiny because the stated reason for the ordinance is not a compelling governmental interest. Furthermore, driver can argue the restriction is not necessary because it is not likely a person would impute such views to the City Council. Therefore, driver does have a meritorious defense based on the United States Constitution because the condition imposed on taxicab operators' licenses restricts political speech based wholly on its content without any adequate governmental justification. Let's look at our other options. Option A, no, because he accepted the license with knowledge of the condition and therefore has no standing to contest it. This is an odd statement because ultimately, had he not contracted or been in a contractual agreement or arrangement, he would not have had sufficient relationship to have standing to challenge the ordinance to begin with. So A would be improper because he'd obviously have to be within the contractual agreement or within the contractual relationship in order to have standing to bring a claim to begin with. Option B is incorrect. No, because a taxicab operator's license is a privilege and not a right, and therefore is not protected by the Due Process Clause of the 14th Amendment. This is inaccurate because there are plenty of privileges that are not rights that are ultimately protected by the 14th Amendment and due process. One of them generally being driver's licenses. And finally, option C, yes, because such a proceeding threatens driver with a taking of property, his license, without just compensation. Generally, the idea of just compensation is usually reserved for real property, not personal property. As a result, C would be inapplicable and D would be the best option. Thank you again for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. We upload content every morning at 8 a.m. Eastern Standard Time. Please like, subscribe, and click the notification bell so you can be updated every time we upload new content.